Hello everyone, my name is Leah Schiffler and I would like to talk to you about collective bargaining. So what is collective bargaining? Collective bargaining is defined as collective action taken by workers to secure better wages or working conditions. For all intents and purposes, collective bargaining is used interchangeably with a more familiar term, unions. I'm going to define a few key terms so that you may better understand the language of collective bargaining. First, the difference between two terms, closed shop and open shop. A closed shop is a business in which union membership is not a choice. It is a precondition to employment at the business. An open shop is a business in which union membership is not taken into consideration as a condition for employment. I also want you to learn the difference between private and public sectors. The private sector includes for-profit institutions. The public sector includes governmental agencies, federal agencies, and state agencies. The public sector was not granted access to collective bargaining until President Roosevelt signed into law the National Labor Relations Act, also known as the Wagner Act. The next term is the right-to-work state. A right-to-work state is a state in which membership or non-membership in a labor union cannot be the reason an employee is denied the right to work. Additionally, trade unions and employers cannot make membership in a union or payment of union dues or fees condition of employment either before or after hiring. Grievances are formal complaints that may be caused by misunderstandings, a lack of familiarity with the contract, or an inadequate labor agreement. And lastly, a strike is defined as the organized stoppage of work by employees. Now I want to talk a little about the history of unions. So, abuse of laborers in America was at one time rampant. Incidents such as factory fires drew attention to the need for the protection of employees. These incidents sparked change. Laborers began to fight to have a voice. In the past, labor disputes were settled by the judiciary branch of government. The courts often ruled collective bargaining to be illegal. Today, labor relations are guided through Congress, which passes labor laws, the U.S. Supreme Court, which offers rulings and decisions, and the National Labor Relations Board, or the NLRB. So what is the National Labor Relations Board? What does the NLRB do? Well, it does a few things. First, the NLRB conducts elections. It provides the legal framework for the organization of labor unions in the private sector employees' workplace, or it works to dissolve the union through a decertification election. The NLRB also investigates charges. Anyone, employees, union reps, or employers, who feel that the rights granted to them by the NLRB are being violated, they can file charges of unfair labor practices at their nearest NLRB regional office. If a change is determined to be credible, the NLRB then facilitates and encourages a settlement rather than litigation. The NLRB is also in place to decide on cases. The legal side of the NLRB hosts 40 administrative law judges and a 5-member board appointed by the President and confirmed by the Senate. Finally, the NLRB enforces orders. This is not always necessary, as the majority of parties voluntarily comply with the board's orders. When the party does not comply, enforcement is sought in the U.S. Court of Appeals. In the event of an unfavorable decision for the party involved, they can seek review of the decision in federal courts. Next, I would like to discuss grievances and the grievance process. As defined earlier, grievances are formal complaints. First, the grievance is brought to the immediate supervisor. Generally, there will be a requirement that the grievance be submitted in writing using a grievance form. Usually, the supervisor and the union rep will review the grievance to determine whether it is valid. Also, most grievance procedures will require that the submission occur within a specified time frame following the event or incident. 3 possible outcomes may occur at this stage of the process. 1. The supervisor and the union rep may determine that no valid grievance exists. 2. The grievance may be resolved. Or 3. the grievance may not be resolved to the employee's satisfaction, and it will move forward to the next step in the process. The next step typically involves the next level of supervisor. In most union environments, the employee will be represented by the union and is not present for the process. If the grievance is not resolved, it will lead to the next step in the grievance process. This next third step in the process will lead to review by a higher level of management and potentially a higher level union rep. If the grievance remains unresolved through the highest levels of management within the company, many procedures call an outside arbitrator in to resolve the issue. Senior leaders from both sides are typically involved in the arbitration process. The purpose of the grievance process is to help the employee to resolve the issue before it becomes serious or results in litigation. As you can see, it is a fairly lengthy process. There are some special conditions that exist in the healthcare profession to protect the patient population. When it comes to changing or terminating a contract, one party must notify the other of its intent to do so 90 days prior to the contract expiration date. This is 30 days more than specified for other industries. If after 30 days of this notification both sides cannot agree, then the Federal Mediation and Conciliation Service must be notified. They will then appoint either a mediator or an inquiry board within 30 days. The mediator or board must make recommendations within 15 days. If after 15 more days both sides cannot agree, then a strike vote can be conducted and a strike can be scheduled. In the interest of patient safety and continuity of care, if a strike vote is affirmed, then a 10-day written notice must be given to management indicating the date, time, and place of the strike. That means there are no impromptu strikes that can happen in healthcare, and management is given time to find ways to continue care for patients. Next, I'm going to discuss types of negotiations. There are 3 types of negotiation: mandatory, permissive, and prohibited. Mandatory bargaining topics are ones that directly relate to the rules laid out by the NLRB. A refusal to negotiate on this type of topic is considered a violation of the NLRB. Some mandatory negotiation points include wages, hours, bonuses, pensions, profit sharing, health and welfare plans, discharges, grievance procedures, disciplinary procedures, drug testing, seniority, promotions, transfers, health and safety, and work assignments. However, it is important to note that mandatory negotiation varies, and that in the public sector, the scope of mandatory subjects is often far more narrow. Permissive bargaining subjects are those for which an employer or labor organization may choose to bargain, but they are not required to. A refusal to address a permissive bargaining subject is not a violation of the NLRB. Examples of permissive subjects include internal union business, inclusion of supervisors in contract, designation of negotiators, marketing strategies, price of employer's product, use of union labels, and taping or making transcripts of negotiations. Prohibited negotiations are subjects of bargaining that are unlawful under the NLRB. These include closed shop clauses, union shop clauses in right-to-work states, and any topic that violates the NLRB or federal or state employment law. Now, I'm going to discuss the pros and cons of unions and collective bargaining. Here are some of the pros. First is power. Unions are a powerful force. They have the power to negotiate, and they are often successful. Part of negotiation is the attainment of better benefits for employees. And along with negotiations for benefits is a big one: negotiations for better wages. And, as I said before, with having the power of a union, these negotiations are often successful. Unions also protect employees from abuses of power. They work to prevent arbitrary terminations, long hours with no overpay, and unsafe working conditions. A union also gives you strength in numbers. One person against a company or an employer is fighting a very difficult battle. When you are large in number, your voice is loud and it is heard. Another benefit is the job security that unions offer. The union protects the employee from being fired arbitrarily. This means a senior nurse will not be fired just to hire a new, younger, and cheaper labor force. And lastly, unions benefit patients. They promote patient safety by negotiating for suitable nurse-to-patient ratios. There are also some drawbacks to unions and collective bargaining. The one that is most important to me is the risk for a strain in the relationship between the employees and their manager. The establishment of a union can create an us-them atmosphere where there is very little collaboration. Unions also pose a risk to competitive edge. If unions are successful in raising wages and benefits, the company or employer makes less and then has to charge more for its services. This ties right into the next problem, less business. If a company or employer experiences a decline in business and revenue, the employees may find themselves laid off. Then there is the question of whether or not unions reward bad behaviors. Picture this. With a union, the employee now possesses a contractual right to seniority. This, arguably, discourages employees from trying to do their job at the very best of their abilities. They are only required to not break the rules. They are not required to excel. Unions also charge fees and dues to the employees for the role they provide. Additionally, employees run the risk of a loss of autonomy. If an employee doesn't agree with the union, they have to go along with the decision regardless. And lastly, the grievance and termination process can be lengthy and difficult. This makes it harder to get rid of incompetent employees as they have to do something outright wrong to be terminated. Okay, so say you decide that a union sounds pretty good to you. How would you go about starting one? Well, I'm here to tell you. The first step is getting the interest. The process begins when 30% or more of eligible employees sign a card to indicate interest. The next step is to petition the NLRB to conduct an election. The NLRB then meets with the forming union and the employer. The NLRB determines who is eligible to participate, establishes that those who signed interest are in fact employees, and sets a date for the union election. Next, the process to select a bargaining agent begins. This can be the most stressful step in the process because during this process, the rules of unfair labor practice apply. Managers are not to discuss anything related to the process whatsoever, nor are employees to discuss it with their managers, at work, or through work communications, such as an employee email account. After a bargaining agent is selected and the NLRB certifies them, you still do not automatically have a contract. You only have a contract when both management of the organization as well as its employees agree on the content of the contract. This agreement is even then eligible for ratification by majority vote. If it is not ratified, you now have a contract. The contract is then upheld by the union rep, who may be a nursing staff member or a member of the union. So what about the nurses of today? What is their role in collective bargaining? Well, today, the majority of nurses are not unionized and do not participate in collective bargaining. However, those that are part of the union tend to make higher wages. What is interesting is the relationship between union nurses and non-union nurses' feelings of wage and job satisfaction. While union nurses report better wage satisfaction, they also report less job satisfaction. Non-union nurses report the opposite. They are less happy with their wages, but are more satisfied with their jobs in general. As far as challenges and solutions for the nurses of today, it is suggested that challenges exist with retaining high-performing nurses and helping them to become satisfied with their jobs. The text suggests partnering nursing staff with management personnel. Problematic, since collective bargaining can cause separation between staff and management, as mentioned in the cons of the presentation. Now, the question is, what does the future have in store for collective bargaining and unions? This is a difficult question to answer. Collective bargaining in nursing presents both opportunity and concern. Unions themselves are having to adjust to adapt to the radically changing healthcare system of today, such as with the implementation of the Affordable Care Act. As mentioned previously, there is concern for unions to cause strife and separation between nurses, rather than unifying them, particularly between staff nurses and management. As the healthcare industry continues to change, it will be interesting to see how unions rise to meet their challenges. That's everything I have to present on collective bargaining and unions. Please ask me any questions you have, and please watch the 2 YouTube videos attached in the next slide. And if you want to, there's a Department of Labor historical timeline related to unions and the labor force. Thank you.